Can you explain to us today how you would disagree or agree with Justice Scalia's view of severability in that NFIB, National Federation of Independent Business case?
What I think I can say without expressing disagreement or agreement for the reasons I said yesterday, not being able to grade precedents. The severability issue, first of all, the majority holding, as you recognized, was that even though the Medicaid provision was unconstitutional, it was severable. So Justice Scalia expressed his view in dissent. Even by Justice Scalia's view, the issue would be different in California versus Texas for two reasons. One, Justice Scalia thought two provisions of the Constitution were unconstitutional. So if you picture severability being like a Jenga game, it's kind of if you pull one out, can you pull it out while it all stands? Or if you pull two out, will it still stand? So Justice Scalia, his view was that if you pulled those two provisions out, could it still stand? And here we're talking about one. And also, Congress has amended the statute since NFIB versus Sebelius, and it's zeroed out the mandate. So now, California versus Texas involves a different provision because of the zeroing out that was done by amendment. So that's how the two cases present slightly different issues.
What do you think of all that?
What do I think of severability? Or
in that instance?
I think the doctrine of severability, as it's been described by the court, serves a valuable function of trying not to undo your work when you wouldn't want a court to undo your work. Severability strives to look at a statute as a whole and say, would Congress have considered this provision so vital that kind of in the Jenga game, pulling it out, Congress wouldn't want the statute anymore. So it's designed to effectuate your intent. But, severability is designed to say, well, would Congress still want the statute to stand even with this provision gone? Would Congress have still passed the same statute without it? So I think insofar as it tries to effectuate what Congress would have wanted, it's the court and Congress working hand in hand.
Thank you. That's quite a definition. I'm really impressed. Thank you.